Good morning and welcome to an oral argument session of the 5th District Court of Appeal. I am Judge Cohen out of Orange County. I'm honored to serve on this panel with Judge Rand Wallace, also from Orange County, and Judge Jim Edwards from Seminole County. We are streaming this on YouTube and recording it as well. I understand that our following is just tremendous. It's even higher than Donald Trump's, but that I might be mistaken about that. We're ready to go forward with U.S. Bank Trust as trustee for LSF8 Master Participation Trust versus Negrani et al. Case number 19-2579. Now I have a default of 5 minutes set for rebuttal, but if you'd like something different than that, please don't hesitate to ask, and we'll be more than glad to accommodate your request. So that said, Ms. Troutman, you may proceed.
Thank you, Your Honor. I'd like to reserve the 5 minutes, please.
Okay.
Your Honors, my name is Shannon Troutman from Albertelli Law. I'm appearing on behalf of the appellant, U.S. Bank. This case arises from a mortgage foreclosure action.
We're well familiar with the facts of the case.
Okay.
So let me start with the issue that strikes me as problematic for you.
Okay.
And that is that these banks just can't seem to get out of their own way. I understand, commercial paper gets sold and back and forth, and that's just part of the nature. And the courts have been very, lenient to allow boarding processes and the testimony as to how that works, and the allowing records from one servicing agent or lender, to integrate into their systems. But now, not only do they have to do that, they have to, the bank doesn't manage their own loans. They have these servicers, and it transfers on and off. They have to contract out with a third party to mail out the notice. I mean, really. And so here, you've got no way to establish that the witness had any real knowledge of the procedure of this mailing firm back at the time that the notice was mailed. And I'm just struggling to see how you show reversible error by the trial judge on that issue.
Understood. And I would start by saying that first, there was an evidentiary issue with regard to the ruling of the default letters, because the collection comments and letter tracker were excluded from evidence. And they should have been admitted because the witness authenticated them as business records, laid the foundation as required by Florida Statute 90.8036. And there was no rebuttal to show that the records were untrustworthy. So they should have been admitted. And in this case, this is where
wasn't there an issue as far as the redactions on those documents, and the witness had no knowledge as far as what went into why the redactions were made, or what was on the document outside of the redactions?
The redaction issue was with regard to the loan schedule and the trust agreement, not with regard to the collection comments or letter tracker. And
wasn't there evidence? Wasn't the witness asked whether the records ever showed the receipt, the return on the mailing?
He was asked that, but as outlined,
and they testified that there was nothing in their records that ever showed a return on the certificate for the mailing, right?
Yes, but the return receipt is not proof that mailing actually occurred. It's only proof that the mailing was received. The
Well,
witness
it could be circumstantial evidence as to whether it was mailed or not, couldn't it?
it could, but the witness went through a very lengthy description of both the servicer and the third-party vendor's process for producing the letters and showing the process through which they confirmed the letter was actually mailed. None of that involved the return receipt being received. That was just an extra level of they could use if the return receipt was received. They
Was there
had
testimony as to this witness's knowledge as to the third-party vendor's practices at the time that the letter was actually mailed as opposed to years later?
Well, he has been employed by the servicer since 2011, which was 6 years before the letter was mailed. And so he has been aware of the policies and procedures of the servicer, which the vendor has to follow since 2011, well before the letter was mailed. The fact that
Counselor, it's not just a technicality here. You've got the borrower affirmatively testifying that she never got the breach or default letters, and you've got the lack of the green return receipt being uploaded. So, I mean, the whole idea behind business records is to show that something that ordinarily happened. But here, Mr. Logue was trying to lay the foundation for what Lender Live does, based on him going there a year after, or whatever it was, after the letter was sent. I mean, just there's too big a gap. He doesn't know whether it's a person who enters the data or information, or whether it's just a program. And, you know, I think we can all agree that computers aren't perfect. They don't always do everything you think they did or should have done. So, you know, that's the missing link here. There really is a missing link with affirmative proof to the contrary.
Well, first, I'd like to say that, yes, he didn't visit Lender Live until after the letter was mailed, but that's not where his knowledge of Caliber and Lender Live's regular and routine business practices comes from. That's from his years of experience and training with Caliber since 2011.
But Caliber didn't mail the letter. That's the problem. Whatever Caliber does is kind of irrelevant. It's whether Lender Live actually generated a letter and put it in the mail with first class postage and all the rest of it. And while you would think they would, and maybe they told you they did, telling you they did is hearsay unless you've got the business records exception. And you don't, you know, you could have had a 5-minute depo from somebody from Lender Live saying, here's how we do it. And, you know, here's run 2030, which included the letter to this particular borrower. And we've got it checked off, double checked. And here's the image. So it definitely was mailed. End of story.
Well, that's where the evidentiary issue with regard to the collection comments and letter tracker not being admitted into evidence comes into play.
Do the collection notes or comments, do they reflect firsthand knowledge of whoever created those collection notes?
I believe so. Yes.
So whoever created the collection notes mailed the letter, is what you're saying?
No.
Then how is it firsthand knowledge?
Because they followed the routine practices and procedures that Caliber and Lender Live had set up. Which
who testified from Lender Live, or who testified that on that day when that letter was mailed, they actually did follow their procedures?
Nobody did, but the Florida Supreme Court.
Then how do you say the collection notes are firsthand knowledge based on they followed their practices?
I would rely on the Florida Supreme Court's recent ruling in Jackson, which stated that as long as the witness has knowledge of the routine practices and procedures, then the business record should be admitted. And then it becomes an issue of the evidentiary weight of those. Additionally, there's
Well, and,
case
and as
law.
as Judge Cohen, Ms. Troutman, as Judge Cohen asked, any knowledge of the procedures that Mr. Logue had came over a year after this process was supposed to have taken place. It wasn't anywhere around the time that it took place. And is that correct?
I don't believe that. I would say that's incorrect. Although he didn't visit the facility until after the letter was sent, he has been employed with Caliber since 2011, 6 years before the letter was sent, and was trained in the policies and procedures of Caliber and the vendors they use that follow their procedures.
Well, but as Judge Edwards said, it was Lender Live who was the organization that sent out the letter, correct?
Yes, but Mr. Logue had knowledge of their regular and routine business practices and procedures.
And but Mr. Logue wasn't able to provide any testimony about the process by which, I mean, obviously you have in the database an indication that letters were sent, but Mr. Logue did not educate himself about what was the quality checking that went behind making the entries into the database as far as the sending of the letter. Like, what is the what are the stopgaps to verify that that's accurate information before it goes into the database? Is that correct?
No, I believe that he did address that, and I would refer you to page 5 through 7 of my reply brief, where he outlined, well, I summarized his testimony, which he made more than once, to outline the procedure that Caliber and Lender Live follow to ensure that the procedure was followed. This includes multiple back and forth quality checks of the information and the letter. The draft being uploaded into a program called Flight Tracker. It would not be uploaded if it wasn't drafted. And then after Caliber approves the letter, Lender Live prints it and puts a certified mail barcode on it, which then is transmitted to Caliber. And that is their procedure for confirming that the letter was mailed.
How do we know the printer didn't run out of paper?
If it had run out of paper, there would be no certified mail receipt on there. It's
Never got a certified mail receipt.
No, but the default letter, which was admitted into evidence to show that it was written, has the tracking information on it. And if
Is
the
there
letter
anything
was,
else there may be another issue you'd like to address, or not? It's your time. Use it as you wish. But
understood. I would say that just to switch gears for a second, the other grounds upon which the involuntary dismissal was granted was based on Caliber's authority to testify on behalf in the matter, because the court determined that they didn't prove that the loan was part of the trust. And I would just point to this court's own precedent that in Marquette that states that you don't need proof of authority to testify as a servicer. So that in itself is a red herring. Again, I would point back to the mailing of the default letters on the evidentiary issue of the collection comments and letter tracker not being entered into evidence. I would point to the Florida Supreme Court's recent ruling in Jackson, which states that as long as the documents are authenticated and the foundation is laid, they should be admitted into evidence. And I would argue that at the very least, based on this, the involuntary dismissal should be reversed and remanded for a new trial based on the fact that these weren't entered into evidence pursuant to pursuant to the Jackson case. The case that the court relied on, Knight v. GTE, is not binding, as there's a case on point in the 5th DCA, PNC versus Roberts. Additionally, Knight is an unpublished opinion and not final, so it has no precedential value. And in fact, the Florida Supreme Court recently issued an order to show cause in Knight as to why the case isn't moot based on its decision in Jackson. And again, I know there was a lot of focus on there being no return receipt, but that was not the way that the policy and procedure was set up for Caliber to confirm that the letter was mailed. That was just later in the process as an additional proof. Rather, the fact that the certified mailing number was placed on the printed out letter, that's what Caliber used as their procedure for confirming that the letter was mailed according to their policy and procedures. So I think the focus on the return receipt is at the wrong place in the, its focus is on the wrong point in time of when that number is important.
Okay.
And finally, I would just say, foreclosure is in the court of equity. Ms. Negrini executed the mortgage in August 2008. By her own admission, she hasn't made any payments since 2010. So she's paid at most 2 years and hasn't paid in almost 10 years, and that's inequitable in all senses of the term. Thank you.
All right, thank you.
Good morning, Your Honors. David Borak. I represent Ms. Negrini in this matter. I think I'll work backwards and start with this last argument that was just raised by Appellant's Counsel, the equity argument. It wasn't raised at trial. It wasn't raised on the motion for rehearing.
Well, it's hard to argue that, a woman that's been in a house for 10 years without making a mortgage payment, that's equitable.
Well, it may be equitable. It may not be equitable, but as far as asking this court to excuse the appellant from its failures below, there's no basis in law for that. The appellant and the plaintiff below had to meet its burden in this foreclosure matter, and it simply failed to do so. I think the panel understood or understands very clearly the issues surrounding the failure to comply with the conditions precedent. And Judge Cohen, I think you hit the nail on the head when you suggested that sometimes these banks just can't get out of their own way. I would go one step further, and I would say sometimes it's actually necessary for the foreclosing entity to bring more than one witness to trial. And they very rarely
they seem very resistant to do that. But see, in my view, they've missed a great opportunity here, because they could have had a vendor prepare the letter, then another vendor put the letter in an envelope, and then a third vendor to actually send it out. They're missing all kinds of opportunity here.
They are. But if you're going to point a finger and say Ms. Negrini, I'm going to use an ugly term, has been squatting in this home for 3 years, sometimes
10 years.
We need
10
to
years.
look. I'm sorry.
10 years.
10 years. It has been squatting this home for 10 years. We need to look in the mirror and take some kind of accountability and say, where are the lawyers who are representing the lender? They've tried this 3 times. They filed 3 foreclosure lawsuits.
It's not part of this record.
Well, it's in our brief, but notwithstanding
It's not in the record. It might be in your brief, but it's not in the record.
With regard to the actual breach letter, Your Honor, the trial court admitted the letter for the limited purposes of showing that it was written, but not that it was mailed. And this court had determined in the Roberts decision, and I'm quoting from the opinion, that mailing must be proven by producing evidence of such as proof of irregular business practices, an affidavit swearing that the letter was sent, or a return receipt. So we don't have an affidavit and we don't have the return receipt, despite the trial court almost begging Mr. Logue, where's the receipt? Where's the receipt? I don't understand where isn't the receipt? You say you could simply go into this flight tracker system and pull it off the computer, but you didn't do that. They failed.
Appellant's counsel's correct on that. Paragraph 22 typically says you have to prove that you mailed it. You don't have to prove that it was received. So, you know, to that point, I agree with her that it's kind of looking at the wrong point in time. But as I expressed to her, when you have a borrower who says, I didn't get the letter, and you have a missing return receipt when there should be one, it does kind of take it out of the ordinary realm of what we usually deal with. Let me ask you this. Talk about the finding that Mr. Logue had to be authorized, deputized, whatever word you want to say, to testify on behalf of the lender or the servicer or anybody else.
So that I think is, I think truly is the red herring in this particular appeal, because, or what I've been kind of in my own preparation for this appeal, calling the Thelma and Louise argument here. If you take a look at the transcript, there is no ruling by the trial court that Mr. Logue was ever struck as a witness. He doesn't reach that conclusion ever. That is not a basis for the involuntary dismissal. If you look at the summation by the trial court determined that the case was dismissed for the failure to comply with conditions precedent. He then worked backwards and went on, and the only way I could categorize it is he went to great lengths to explain why he was excluding certain items from evidence. Now, in my opinion, all of these items are unnecessary. And the appellant argues we didn't need to show capacity in the first place, because capacity is grounded in the evidence code. It's not grounded in contract. Well, you know, when I'm wearing my trial attorney hat and somebody presents evidence that's clearly flawed or presents evidence, you question it. If you don't need to show capacity, for what reason are you introducing as your first exhibit a power of attorney? And if you don't need to prove capacity, for what reason are you attempting to introduce a mortgage loan schedule that has no earmarks that it relates to this particular trust in the first place? And if you do not need to prove capacity, for what purpose are you introducing an incomplete PSA that's almost entirely redacted? I would have been remiss with these documents being introduced to just sit there and do nothing.
Mr. Borak, can I ask you a question?
Sure.
I've missed the Thelma and Louise analogy.
The Thelma and Louise analogy, Your Honor, is that I followed them off the cliff. You know, in the movie Thelma and Louise, they drive off the cliff at the end of the movie. So they
I hadn't seen the movie, and now you've ruined the ending for me.
they take this leap that somehow in their brief, one of the bases for the appeal is that the trial court granted the involuntary dismissal because of the witness was struck for lack of capacity. And I followed him right over the cliff and said, no, he didn't. Or that, you know, your client didn't have capacity. But it's neither here nor there, because that's not what the trial court ever ruled in the first place. It's very apparent in the transcript. And further, if that was truly the ruling by the court, there would be no evidence in the record. If the witness was struck, how would there be any documents and evidence whatsoever? Nothing was stipulated to. The payment history only could have come in through a witness. And if the witness was struck, we would not have a payment history. So this notion that the witness was struck, it's just patently false. So
boil it down to very simple terms. Had they properly proven through a competent witness or through appropriate business records introduced into evidence that the default demand letters, acceleration letters, whatever you want to call it, had been sent pursuant to paragraph 22, then this loan should have been foreclosed and the mortgage foreclosed, and the bank would have had its judgment anyhow and sold the property if it wanted to, correct?
Probably very true, Your Honor. I
Oh,
will.
no. Don't give us a probably. Yeah, because, that wasn't the question. Would they have been entitled to judgment?
I will say based on the record, yes.
Okay, well, I'm not trying to get, this is not a request for admission for your next trial. It's just, that's really the issue. They didn't prove the demand letter was sent under paragraph 22.
And that really, and that's really the crux of the case here, Your Honor, because essentially at that point in the trial, in my mind, it was it was done from my perspective. So any other arguments I would have intended on making from a strategic standpoint, I thought potentially had the effect of watering down anything else. So that being said, the answer is yes. I think that barring their inability to get the breach letter in for the purposes that it was actually sent, they probably would have been entitled to, they would have been entitled to their judgment.
Okay.
With regards to, I believe we've touched on the capacity issue. I did want to mention very briefly, because the Jackson opinion came out after we had filed our answer brief. And I do believe that it is unremarkable as far as this case is concerned. It settles the issue between the fourth and the second, and now, for the entire state, as to what the proper predicate is for laying the business records exception to the hearsay rule, and really who has the burden and how it can be attacked. But that's not what this case is about. This case is about double hearsay, and there was nothing in the record whatsoever about Mr. Loeb testifying as to Lender Live's business practices. He never goes there. There are plenty of acknowledgments in the transcript that collection log, the letter log and the collection communications, that those were created by Lender Live. So, and the trial judge had an issue with someone at Caliber simply parroting that information and typing it into their own records without establishing first that they were created by someone at Lender Live who could satisfy all of those predicate questions to get beyond the hearsay exception. And they never did that. And they tried to come in a backdoor by arguing and questioning the boarding and suggesting that it came in as through some kind of boarding process. But Mr. Loeb nipped that in the bud himself, and he said, no, this isn't the boarding process. And it isn't, and it shouldn't be, because I think, as this panel has already suggested, the boarding process is very simple, and it's a low bar. When one lender transfers their portfolio to another, or one servicer takes over for another, they can adopt all of their records essentially as their own. That's not what we have here. We have a wholly separate, unaffiliated entity. And we shouldn't simply suggest that when you go out and hire a third party and they work for you and they say, here's the work we did for you, you can then say, okay, those are now my records, because you will forever change the bar that people need to clear. What would be next? You find something on the street and you could then claim, well, now that's my business record because I found it and I took it back and I put it in my safe, and we now keep that in our ordinary course of business. I just don't believe that is the slippery slope we want to go down. So I truly believe that when you couple the fact that Mr. Logue had no knowledge, or well, maybe he has knowledge, but he certainly didn't testify that he had any knowledge as to Lender Live's business practices. The fact that he visited Lender Live 14 months after the letter was actually written and allegedly sent, he would have had to have testified that he knew what their practices were back then. He didn't go there. There's this clouding of issues where the appellant is trying to suggest that Caliber, because he knows what Caliber's practices are, that somehow they're able to come in the back door, and it just doesn't work that way. I'm happy to answer any other questions the court has, but I believe I'm done with my presentation for the court. I respectfully request that the court affirm the trial court's decision and uphold the involuntary dismissal.
All right, thank you, Mr. Borick. All right, Ms. Troutman, rebuttal, you've got a little over 4 minutes left. No penalty if you don't use it all.
Unmute myself. Thank you, Your Honor. Again, I want to return to this argument that Logue had no knowledge of the policy and procedures, and that there was nothing that Caliber used to confirm that the letter was sent. First of all, we keep talking about the timing of Mr. Logue's visit to Lender Live. The issue of timing was not raised below. It wasn't raised during the trial. It only first appeared in the answer brief. And again, Mr. Logue has been employed by Caliber well before
Ms.
the letter
Troutman, was
sent.
there any testimony in the trial court that the procedures that were in place when Mr. Logue went to, when he did educate himself on the procedure for sending out the letter, and when the letter was allegedly actually sent, were those procedures identical?
I don't recall if there was testimony to that, as the issue was never raised. There was also no evidence that there was any other procedure in place.
So at best, it was speculative that the procedure remained identical from the time the letter was allegedly sent out to 14 months later.
I wouldn't say that it was speculative. I mean, the requirements of showing that a letter was mailed have been around since well before 2000.
You know, in my view, Ms. Troutman, it's one thing, you know, to go through the boarding process and then to say that I'm going to allow an expert from this servicer or this bank to testify as to a prior servicer or prior bank's records and effectively adopt them as their own. And then, but then to keep extending that and to go to third parties and to say, well, you know, I went and visited them and I talked to them about their procedures and their processes. And now, you know, I'm qualified as an expert in their business, you know, processes. You know, listen, if you're going to go to third-party vendors, then call a witness from the third-party vendor.
Okay, I understand what you're saying. I don't believe that the case law requires that. And again, in this case, the focus continues to be on the lack of the return receipt, but that wasn't the procedure that Caliber followed to confirm that the letter was mailed.
Counselor, we're not focused on that because I totally agree with you. It's not whether the letter is received or not. But here you have the borrower saying she never got it, and you have the lack of the return receipt. And at best, you have a witness who says, this is what they're supposed to do. And if everything worked right, then the letter got sent. But we don't know if everything went right. That's the whole problem. That's, you know, again, if you're going to use a vendor to, not you, but your client's going to use a vendor to mail these default letters, it needs to have somebody from that vendor confirm that it was sent in one fashion or another, not just that's how it was set up to do and we figure it happened. but we don't know. I mean, and again, if you're going to prove up the normal business practice of mailing, then you have somebody who actually does the mailing say, this is how we do it. We do this, we do that, we take it to the mail room, and Joe, our mail clerk, takes a box down to the mailbox every day at 5 o'clock. But that testimony's not here.
I would again just argue that they have the procedure. The letter is shown to be mailed when the return receipt number is placed on it. Caliber confirms the
I mean, in
image of that
actuality,
letter.
to get a return receipt number, the vendor could have a big stack of them, because we've all sent registered mail before. And if you've got a business where you send out a lot of registered mail, you literally have stacks and stacks of it. So the number goes on when it's still sitting in your office. The fact that it's got a number on it means somebody was getting ready to mail it. It doesn't prove it was mailed. That's a big problem. You don't get that number when you go to the post office. You've already got it in your office. It does not prove it's mailed. It proves you are going to mail it perhaps. But paragraph 22 doesn't say you're gonna mail a letter. It says you did mail a letter. And that's the whole problem here. And I understand your argument. I'm not trying to pick at you on that, but that's an important distinction of the world as it works, that a certified return receipt number doesn't mean it's mailed. It means it's maybe getting ready to mail, which is, again, circumstantial evidence, but it's not proof that it was mailed. And it's the bank's obligation to prove that it complied with paragraph 22. That was raised here, that was put at issue, and the burden of proof wasn't met according to the trial judge. And you might get an indication of what some of our thoughts are on whether it was met or not, but you may want to have a discussion with your client on future cases.
All right, thank you, Mr. Outman. Thank you, Mr. Borak.
Thank you.
We'll be in recess.